Hello and welcome everyone to my presentation on time at large in construction contracts. Time is defined as at large when there is no specific time for completion of a project or a previously fixed time for completion is expired and not applicable anymore. Time at large has no enforceable date for completion. The contractor has an implied obligation to complete the works within a reasonable time. Construction contracts generally include a date by which the works described in the contract should be completed. This is the date by which practical completion must be ensured. The time at large describes the situation where there is no date for completion or where the date for completion has become invalid. The contractor is then no longer bound by the obligation to complete the works by a certain date. It is not uncommon on construction projects that the works are not completed by the date for completion. If this is because of delays for which the contractor is responsible, then the contract will include a term to pay liquidated damages to the employer. These are predetermined damages based on a calculation of the actual loss that the employer is likely to incur if the contractor fails to meet the completion date. Some contracts require that a certificate of non-completion is issued as a prerequisite to deducting liquidated damages. If the works are delayed because of events for which the employer is responsible, for instance, an act of prevention, the contract will provide for an extension of time to be granted, changing the completion date. If contracts did not allow the construction period to be extended under such circumstances, then time would be at large. The employer would then not be able to claim liquidated damages from the contractor as there would be no date against which they would be calculated, and the contractor would then only have to complete the works in a reasonable time. The employer would only be entitled to damages if they could establish that the contract was not completed within a reasonable time. It is important, therefore, that clauses describing relevant events cover all necessary eventualities. Otherwise, if an event occurs that is not covered, time will be at large. Cases of time at large. When a contract is executed without a date of completion stipulated in the contract, for example, when a letter of intent is issued, simply instructing the contractor to commence the work without stipulating the completion date, and where the subsequent contract do not refer to a time for completion, then the time will be called as time at large. Second case, an act of prevention by the employer creates a delay, which in turn is not covered by an extension of time provision, or the provisions for extension of time not being properly administered or applied, or there has been undue interference by the employer in the certifying process. Case law on the subject. The case law established the fundamental principle related to the commercial contracts. In Begg, Kilpur, and Bryant, the court stated that there is a term implied in every contract by each party that it will not do anything to prevent the other party from performing a contract or to delay him in performing. Generally, such a term is by law implied into every contract. In the absence of an express EOT clause or its application, a default of the employer that affects the contractor's ability to complete the works on time could put in place time at large. In the case of Amalgamated Building versus Waltham Holy Cross, Denning LJ stated that where the cause of delay is due to some act or default of the employer, for instance, delay in giving possession of the site, unstipulated time, or something of the kind, the contract time may well cease to bind the contractor because the employer cannot insist on a condition if it is his own fault that the condition has not been fulfilled. This was confirmed in Roberts and Bury Improvement Commissioners. Case law confirmed this in many other cases as well. The contractor's obligation. When time has become at large, the contractor has the obligation to complete the works within a reasonable time. In Fisher and Ford Motor Company, this was defined as a question of fact. However, each case is required to be viewed on its own merit. What constitutes a reasonable time? First school of thought. This assess what constitutes a reasonable time for completion after time at large by adding a reasonable time allowance to the original time plus any previously granted extension of time for delays occurring prior to time becoming at large. Second school of thought. This is based on the concept that the original time was not in any case reasonable since it was presumably agreed under a certain amount of stress in competition with other contractors. In this case, the whole circumstances surrounding the projects are examined and a reasonable completion date is determined. This is to be noted that provisions related to the notices within certain period of time which are a prerequisite for any claim of time at large is meaningless because once time is at large then the notice provision is irrelevant. Notice for EOT. When a notice is required within a specified time under the contract and this notice is a condition precedent to an EOT to be granted, and if such notice is not issued within a specified period, then applying the EOT clause in the contract under which delays by the employer will give rise to an extension of time will be rendered inoperative. Then time will be at large. The employer would be unable to impose liquidated damages. This was confirmed by Australian court in the case of Gaymark Investment and Water Construction. In this case, Gaymark as an employer was responsible for a certain period of delay. The contract provided that the contractor had entitlement to an extension of time due to the employer's delays. However, notice was the precondition in the contract. The contractor had failed to give notice within the specified time. Gaymark imposed LDs due to the reason of delay. The arbitral tribunal in its award held that the delay caused by the employer constituted an act of prevention which put the time for completion at large. The employer lost the right to impose LDs. Decision of appeal court in Gaymark case. The appeal court stated that acceptance of Gaymark's submission would result in an entirely unmeritorious award of LDs for delays of its own making costs because of the contractor's failure to comply with the notice clause. However, when the delays are not caused by an act of prevention by the employer, the decision given by the court in Turner Corporation and Aristotle will apply. In this case, the court ruled that if a contractor have a right to claim an extension of time, fails to do so, it cannot claim that the act of prevention which would have entitled it to an extension of time for practical completion resulted in its inability to complete by that time. A party to a contract cannot rely upon preventing conduct of the other party where it failed to exercise a contractual right which would have neglected the effect of that preventing conduct. In the Scottish case of City Inn and Sheffield Construction Limited, the inner house of the Court of Sessions has given ruling on appeal that the contractor who had failed to give notice under EOT clause was not in breach of contract in failing to give notice of delay arising out of an employer's instruction. Conclusion. Some standard forms of contract provide issuing a notice a condition precedent to granting an EOT due to the danger that failure to comply with the notice clause could put time at large. However, some standard forms which make a notice a condition precedent is the FedEx condition of contract and Nowlin Canton Railway Corporation conditions of contract in Hong Kong. It is expected that implementation of gay mark ruling may cause a rethinking in future to ensure the contractor's right of EOT in case of its failure to give notice where delay is attributed to the employer. Thank you.